Stanford University.
This presentation is delivered by the Stanford Center for Professional Development.
All right, we're going to get started. There's one thing about, before we jump to infringement today, there's one thing about patentability that I want to talk about. And I often use these Venn diagrams to just kind of show a little bit about what, the coverage that we're trying to get and maybe the coverage of the disclosure of the prior art. If this is what we're going after with our particular patent application, and this is what the prior art is kind of showing or disclosing, teaching. What some of the assignments that I saw for the patentability opinion focused on the other aspects of the inventions of the prior art. Effectively, what was different, what else they disclosed, and how that additional information was different than what the invention was. This information is actually, what else they disclose is completely irrelevant. And the only thing that's actually really relevant is what they did disclose. And then to focus on the space of what they did not disclose. But this area right here, which is the additional information that piece of prior art disclosed, is not relevant to patentability. Does this Venn diagram make some sense? And so the fact that it has additional aspects or additional features that's different is completely irrelevant. Focus on what your invention is and what aspects of it were disclosed. And then how these certain aspects were not disclosed. Not what else the prior art talked about. Because when the patent office does the analysis, they're going to look for your invention, and this is all they care about. What else this discloses, they're just going to pick one paragraph out of a patent application or an issued patent. They don't actually even care about the rest of that document. They're just going to pull that out and say, look, this thing was taught. Question?
Is that determination of, I guess, what the green part and the black part is that subjective for the most part, or?
No, I mean, this is something where you're going to go into the patent office with a patent application that has a claim. And so this might better be shown as with a bubble map, so that there are a couple of different elements that you're going after, and that the prior art now discloses 2 or 3 of these bubbles. So that might be one way of thinking about it. And it either discloses it or it doesn't. And there's some arguments there, so there's some subjectivity there, but for the most part, this is, does it disclose it or not? And when we go back to fight that obviousness rejection or that novelty rejection, one of the best arguments we can make is it doesn't actually disclose that. But we never talk about, well, look at all the other things that it discloses. It's clearly doing something different. We focus on that particular element right there. Now, sometimes this comes into play when we're trying to show that it teaches away, like the combination of this prior art and this piece of prior art, they wouldn't go well together, and we're looking at some of the other pieces there in that document to show that you can't combine these two things together. But it doesn't, that other aspects don't come into play on whether or not something is showing a particular element of the claims. Okay. That's all understood. I'd like to move on to today, which is a radically different topic. Today we're talking about infringement. Early on in the course, I talked about 2 different sides of patent law. Whether or not something is patentable, which we've now spent a good chunk of time on, and whether or not a particular product infringes. We'll talk next lecture 2 weeks from now. Reminder, next week I'm actually going to be out of town. So 2 weeks from now, we'll bring this all together and have a nice review of what is patentable and what is an infringement, and we'll talk about those things and kind of do a nice little compare-contrast thing. But for now, for today, this lecture, we're focusing on infringement issues. Any procedural questions before we begin today? Great. Sing Cassidy. What actions, kind of verbs, invoke infringement of the patent?
Use and sell.
Awesome. There's another two in there, but those are the ones that I want you to get. Make, use, and sell. Is patent in there? Filing for a patent application? Getting an issued patent? Are those parts? Can filing a patent application infringe another patent? That's actually really important. This is just a tiny little sidetrack right now, but that right there is really important to understanding patent law. Filing a patent application is not one of these words: making, using, and selling. And these are the only verbs, along with offering to sell and importing, that are actionable for an infringement. The patent is limited in two ways. It's limited by time. It's also limited by geography. We talked a little bit about this earlier in the course. The patent application is going to expire 20 years after the filing date, which is different than 17 from issuance, which is what it originally was for a couple centuries. And then the other aspect is geography. There is no such thing as a worldwide patent. There is such a thing as a worldwide patent application, but it doesn't actually grant into a worldwide patent. Right now, if you have a U.S. patent and one of your competitors makes something in France and sells it in Mexico, and then that's later on and turned and sold and shipped to Canada, as long as it's actually not crossing the United States border, there's absolutely nothing you can do with your United States patent. But when it does, in the United States, a competitor makes, uses, or sells, then that's something that you could go after.
Just out of curiosity, often you see people try to penetrate new markets, taking the intellectual property from other countries.
I've heard that this happens all the time. I haven't had any of my clients rip off that particular way. In some ways, this is kind of like the second or third shift at a Chinese factory. You know, that, hey, there's the two shifts during the day. They're selling those particular pieces or parts or components or systems, devices to a company in the United States, and then they're selling a third shift in a different market that's not going to infringe a particular patent, in the United States. And so, we hear about these things, but I don't actually have any data to suggest the magnitude of that practice. Yeah.
You mentioned shipping to the United States. Would shipping product, even though you're not using or selling it through the actual geographic United States, be considered infringement?
It falls under import. So as long as you're importing it into the United States border, then yes. More interesting questions would be, what about low orbit over the United States? High-speed train that doesn't actually stop at a border or something like that.
So then, you have to have patent attorneys in a shipping company to make sure that you route your proper products around the covered zones.
Good questions. Nick Chang. How many elements of the claim must be found to establish infringement of a claim? And so these are elements. So an element is kind of the components of a claim. So let me just kind of make sure that we all understand my nomenclature here. And so maybe these are like bullet points of a claim, or kind of the bubbles that are in a claim. And so if a claim has 5 elements, how many of those need to be infringed in order to establish infringement? It turns out that's not the right answer. Could someone help me out with that? Yeah.
Well, that's all elements rule.
All elements rule, right. And so this is actually the confusing part when, and I think you're answering the very next question, Nick, and so we'll give that to you as well. But in terms of the elements of a claim, all of them have to be there. And so when you think about the elements of just, all right, so it's these particular bubbles, it's when, I don't have my adult sippy cup today, but it's, if we drafted the claim and we got the claim allowed, this is the valve and this is the spring and the articulated cantilever and all of those things together with a period at the end. Now, if someone just made a valve, that's not going to be an infringement. It's going to be every single one of those elements, so all of those together, that would establish an infringement of that claim. What percentage of the claims need to be infringed to establish patent infringement of the patents? This goes back to you, Nick.
What percentage of the supposed to be infringed to establish patent infringement?
So there's 20 claims. Like how many of those claims, what percentage of those claims need to be infringed in order to establish infringement of that patent?
Just that one.
Just one. Okay. So the total got it. And that answer now works perfectly. Great. A patent owner only need to establish the infringement of one claim. And so oftentimes they hear, we got a great patent. We got 78 issued patents, or 78 issued claims. It's awesome. Sometimes the number of dependent claims or total claims could give some kind of indication of with the dynamic range of that particular patent scope. That it started off really broad and now they have a lot of very narrow claims as well. And so that may establish something that might be strong. You might also have 78 absolutely worthless claims. And you compare that with another patent that just has 3 claims, and those claims are incredibly broad, incredibly valuable. And so the number of claims really don't have anything to do with it. Modest, I don't want to say anything. A modest, tiny amount to do with the value of that particular patent. Being able to say, this, we have 1 issued claim or 78 issued claims on a patent. That doesn't answer the question of whether or not that's actually valuable or a strong patent. The 78 claims, if they're nested, then that might have some better strength against attacks on the invalidity of that particular patent. You actually have to invalidate a significant number of those claims to invalidate the patent, whereas another patent that only has a few claims might be easier to invalidate. And so in some ways that might be stronger or more valuable, but it really depends on what the actual coverage of those claims. Yes?
So if somebody has an invention which has everything that's in a claim of a patent, plus it has more that changes that somehow, like the sum of that is different from what was before, that's still a patent infringement.
Do you want to take on the next question? So widget, comprising a first component, a second component, a third component. Actually, it's a little bit different. I had another question that was actually very, very similar to the question you just asked. And so the concept that you're asking there is, so we have more than just that claim. Is that a good summary of that particular question that you just asked?
Yeah. So somehow it has like a different result.
Patent attorneys love this example of the 3-legged stool. And so like when you ask a patent attorney, like, oh, well, tell me about claims. They're like, oh, well, let me tell you about the 3-legged stool. And so the concept of the 3-legged stool is that I might have a claim on a horizontal platform that has 3 legs that extend downward towards the ground and therefore support the platform at a distance, otherwise known as a stool. So someone else comes around and makes a 4-legged stool. Does that infringe?
Yes, it does.
Who would say otherwise? I mean, the claim says 3, and the stool has 4.
Well, I guess if you could show that you only have 3 of that design, 3 legs of that design of 4 legs, it wouldn't hold the platform.
Way too complicated. No, it has nothing to do with it.
Well, the difference is not substantial, right?
That test doesn't have anything to do with it.
Yeah.
It's a lot simpler than all this.
four-legged stool still has three legs.
Yes.
Yeah. No, it just supported.
That's
what I'm
it.
saying.
No. It just has 3 legs. And if they extend downward from the platform down to the ground, which I can't imagine a stool that only has 2. So as long as it has 3, then it's going to infringe. And that's the answer. And so a 4-legged stool has 3 legs. And so therefore it infringes. The fact that it is a 4th leg is mildly interesting, but it's not from the patent law standpoint. It's still going to infringe a claim that says some kind of platform with 3 legs extending downward towards the ground to suspend the platform at a distance, otherwise known as a stool. Does that answer your question earlier?
So, like the sippy cup,
Yeah.
each of those parts that you described, most of those things are things that probably have been claimed by other people individually.
Mm-hmm.
So, how come that doesn't infringe?
I never said it didn't. It still could be patentable if it's putting together in a new combination in a way that's non-obvious.
Patentable, but then infringe.
Now we don't have to show up for 2 lectures from now. That's the whole crux of this course. Awesome. But yes, that right there, that particular insight is going to be incredibly important 2 lectures from now, or 2 weeks from now when we have the next lecture. We're focusing today on infringement. Yes.
Kind of like a hypothetical question, but what if, let's say, you had the platform with 4 legs, but it's no longer a stool? Like it serves a different purpose.
So it's a podium, or it is a table. So patent law doesn't really care about use, for the most part. Sometimes you could claim a method of using something. Because that's actually what the invention is. You're using something that's already out there in a new way. But for the most part, when you're claiming a structure, you're not actually claiming a structure with an intended use. And so the fact that you're using it in a different way doesn't get around the fact that you have that exact structure. There are 2 different types of claims, independent claims and dependent claims. This is just a shorthand way for us back in the day when we're on typewriters to make it a lot easier to write claims. It's literally just a copy and paste when copy and pasting was a little bit more challenging. And so this was something that, hey, everything that I talked about in this previous parent claim, in addition to that, I'm adding these things right here. So it might be a platform with 3 legs extending downward towards the ground, thereby suspending the platform at a distance. And a dependent claim might be further comprising a 4th leg. What else might you add to that particular claim? What else does stools have? You guys have seen stools, right?
Further comprising additional struts between the legs to increase structural support.
Awesome. So it might be a brace that extends from one leg to another leg, a distance from the ground and a distance from the platform. Fantastic. But that would be a dependent claim. We could write that as an independent claim. And if we wrote it as an independent claim, it would look a little bit like a platform having 3 legs extending down to the ground, thereby suspending the platform a distance from the ground, and including a truss or a brace extending from one of the legs to another leg, a distance from the ground and a distance from the platform. So that dependent claim is just a rewrite of that independent claim. But it does allow us a little bit of shorthand later on when we're dealing with patentability and when we're dealing with infringement. I think I skipped a question here. Yep, I did. John Eakins?
Yes.
John. So If the independent claim is not infringed, the dependent claims cannot be infringed. Why is that?
Well, because they're dependent on the independent claim.
It's a little bit circular, but go ahead. That's a good start.
Well, because the independent claim, as you stated, is not infringed, and so there's nothing that can really be infringed regardless, even if, I don't know, are you trying to have me explain the relationship with dependent and independent
Help me
claims?
understand this concept.
Well, because, as you mentioned, it's kind of a copy-paste idea where the dependent claim actually includes everything that was listed in the independent claim.
Yep.
And so, as a result, if the independent claim is not infringed, then you can't go after this.
What does that mean when the independent claim is not infringed? What am I implying there? Or actually just stating?
That the... I'm not sure what you're getting at.
What am I saying about the elements that are in the product that I'm trying to compare it to this particular claim? If I say that the product doesn't infringe that independent claim, and there's 3 or 4 elements here, what am I saying that when it doesn't infringe?
It's not similar enough. It's not running away with the idea. I'm not.
Along those lines, and so that it's different in some way. We'll come back to kind of give that a little bit more clarity. And then when you add the dependent claim, what are you doing?
You're narrowing the scope of the claim.
Yep. And so are you going closer or further away from the kind of like that difference, right?
Okay, I see what you're saying. You're going further away from that difference.
So when you look at an independent claim and it's not, thanks, John. When you look at an independent claim and it's not infringed, then the statement really there is that one of the elements isn't found in that product. It doesn't have 3 legs, or it doesn't have the horizontal platform. And when you have a dependent claim that's adding a brace, it doesn't matter. It's still missing the horizontal platform. When you have another dependent claim that's adding now a back, it doesn't matter. It's still missing the horizontal platform. And so if you do not infringe an independent claim, you cannot infringe a dependent claim because you're still missing something. And that dependent claim is just going to add more stuff, but you're still missing something. There's something about that independent claim that's not there. And you can go ahead and add more things, but there's something that's not there, and they're not going to be able to change that. This is an AND gate, and the first equation wasn't satisfied, and you're adding a bunch more things, but the first equation wasn't satisfied.
So all claim is interchangeable with all the dependent claims. You can switch them around in order and get
Tell me a little bit more about what you mean by interchangeable.
like permeable or commutable. If you can put dependent claim number 5 back as an independent claim and move independent claim down.
We do a little bit of that when we make amendments to claims. That effectively that language is there in Claim 5. All of that from the parent claim that it depends upon. All of that language is kind of really still there in Claim 5. But I wouldn't characterize it the way that you did, in the sense that later on that these things are can be moved around like that. I think this will come clear in a few minutes. If not, let's circle back.
What is, in terms of, I understand, I guess, when you're making a dependent claim, it's making it more specific and you're kind of adding elements. So if you wanted to protect others from patenting a certain idea, then you can patent that, make a dependent claim. But in terms of like when you're having an infringement case, will those dependent claims that you added on top of your independent claim, if it's infringing all of them, do you get more money? Like, can you ask for more damages, or what's the purpose of having?
Why do we have this? We talked about it once, a lecture long time ago. Why do we have this? Why do we have dependent claims?
Invalidated, then you can still claim the other ones.
So when you're in the middle of litigation, and you may want to say that claims 1 through 10 are infringed, claim 1 is nice and broad, it's really clear, you don't have to argue it. 10 might be really narrow, and you might have to get some correct interpretation just to make sure that a judge sees and agrees with you. So why not just go in there with claim 1? You might want to have those other claims as backup claims, because if you're the defendant in the particular lawsuit attacks and successfully invalidates claim 1, you don't want to have to go back later and say, all right, you're right, but now I'm going to sue you on claim 2.
But if they don't infringe claim 1, then
I didn't say not infringe claim 1, I said invalidate. So what happens when you invalidate? What am I saying there? If someone now invalidates a particular claim.
I think every case is different, but I think at the broadest level, you prove that it was not, well, not necessarily the logic, but not a valid claim, and that can mean that it didn't hold up to the requirements in patent. You can say it's not useful, not obvious, or not. Yeah.
And most likely what you found is some piece of prior art and said, all right, well, the patent office didn't do a very good job. And so the patent office should have not allowed this to go through. It wasn't patentable, the first part of the course. It didn't satisfy that novelty or obviousness those requirements. And that's something that you're going to argue every time. So there's two ways of kind of getting out of an infringement. One is that your patent's no good, and the other is we don't infringe. Why not argue both? You're most likely much more motivated than the government agency to try to find a piece of prior art. And so you'll most likely argue that it's invalid. Sometimes you might argue that's invalid and not necessarily push too hard on that you didn't infringe. Yes?
If you do manage to argue that it is invalid, what happens to the patent that you are arguing against? So what happens to that claim?
And so you may strike down claim 1, but claim 2 might still be valid.
The patent that has that claim 1, is that claim 1 removed from that patent?
No, so those patents are never updated. And so we don't actually know when we're looking at a patent, has this particular patent been litigated before? Has a court held that this particular claim is invalid or still valid? By just looking at the patent, we don't have that information. Not easily and cheaply. There's a couple people that are working on that, actually right here at Stanford. We talked about this, two main types of claims, independent claims and dependent claims. Dependent claims include all of the limitations of the claims on which they depend, plus additional limitations. If the independent claim is not infringed, that means that one of those limitations is not found in the independent claim. And so it doesn't matter how many more limitations you add, you're still going to find one that wasn't there. Brandon? So your client owns a patent, and the patent has a really simple claim. It's a widget. It's got a first component, second component, and third component. The client wants to know if one of their infringers or one of their competitors infringes this patent. What do you do?
From my understanding, there's two basic steps and two variations. The first step is to really understand the claims and all the elements in those claims, and then compare it to the accused product or method. And then those two variations are literal infringement, and then you can do it under the equivalent doctrine.
Awesome. That's perfect. Thank you, Brandon. We need to interpret the claims. This one is pretty simple. It's got a first component, a second component, and a third component. But we actually need to know what that means. And that's where we lawyers get to fight over, well, what does that word mean? What does it mean when you have that comma right there? And so this other phrase, is that now going to modify the word in front of it or modify the phrase in front of it, and we get to argue about what this thing means. And once we figure out what it means, then we could turn around and say, well, does it have this or not? And so we need to interpret, and then we need to compare. Most of the time, people just jump to the compare step. And they don't actually do the interpretation step. As Brandon mentioned, there's this thing called the doctrine of equivalence. It's the exception to the rule of literal infringement. What's the test for doctrine of equivalence? Danitza? How do we know if something is equivalent when we're trying to figure out infringement?
First, we should look at whether the difference is substantial or not, and whether it is we are actually think difference. So usually, depending on the scope of the patent, we ask, for example, clinical specialists or people looking at art to determine whether the change is substantial or not.
This is close in some ways. What is being described here?
Under this, it would be looking at whether the particular invention or the claims capture doing the same function, basically, in a similar way to get a similar result.
Great. So the function way result. What you were describing was more like an obviousness. And so whether or not something would be obvious, you look to someone skilled in the arts. And so totally legit test, but on the opposite side of the law. And we're going to talk about like how these two things are actually similar in many ways. What's your name again? Thanks, Layla. And this was called the function way result test. If something is being done in a same function, substantially the same way, to obtain the same result. We're getting into some of the kind of nitty-gritty to infringement law here. Ken Wang? Ken? The doctrine of equivalence allows the patent holder some, wiggle room. When do the courts close the door on this wiggle room?
If there is a previous example, are we talking about an exception to this?
Yeah.
So if there is I'm not sure how to phrase this. So basically, if there's a previous example that
there's certain actions that when the patent holder takes that would kind of say that, look, you don't get this doctrine of equivalence anymore on this particular phrase or this particular element. And what's that action?
I forgot this.
Okay. Can someone else get out? Yeah.
The estoppel.
How does it work?
So if the person who's claiming his patent, if he's narrowed the definition of it previously,
yep,
he can no longer claim the difference between the original claim and the narrowed version of it.
Okay. Awesome. Remember what this was called? So it's estoppel, but do you remember where that came from? What's that?
I think the historic estoppel in case
prosecution history estoppel. That's awesome. You remember the exception to it?
Franco exception.
Festo one. Can someone explain that particular exception?
So I think there were 3 conditions. So one was this product would have been unforeseeable when they were doing the narrowing.
Yep.
And 2 is that there's a there's a tangential relationship between the equivalent and the product, or the equivalent product that's in question. And then the third part is that there's some other reason that the patentee couldn't foresee the equivalent.
Awesome. What are both your names real quick? Thanks, Kathy.
Rita Banerjee.
Thanks, Rita. This isn't the most fun part of patent law, or maybe it is if you're a hardcore litigator. The Festo case talks about prosecution history estoppel. It prevents the patent owner from recapturing some of the subject matter that they gave up when they were amending. When do we amend? What does it mean when we amend the claims?
During prosecution, the patent office, for one of the three reasons.
Yep, you get an office action, and you get some kind of rejection. Hey, look, it's too close to this other piece of prior art over here. Okay, you're right, examiner, and we're going to amend the claims. And so we're going to add this narrowness, add limitations, and make the claim a little bit more narrow. We're not going to go as broad anymore. We're going to make it more narrow. What we want is a little bit more specific than what we asked for before. And when we do that, we start to lose this concept of doctrine of equivalence. Doctrine of equivalence in and of itself is an exception to literal infringement. The doctrine of equivalence, you get, that's the exception. But now there's a rule to say when that applies and doesn't apply. And now there's another rule to say when that exception applies and doesn't apply. And so what we have here is a rule with an exception, and an exception to that exception, and then an exception to that exception to the exception to the rule. Discuss with your neighbor whether this makes any sense.
Except when this is, I'm not really sure I understand what What's the No. The first step is so you. Well, there's the literal thing, and then there's. Okay, I don't know where you're in. Yeah, like it's a substantial difference.
So I use, with indicating 1A instead of.
Right. Well, but then you're not really infringing it.
I say, well, you exempted 1A during.
Because you narrowed it during prosecution, so I'm not really infringing it. Then
you come back and say,
well, actually,
I couldn't have been foreseen
so like I could see this condition that's go on forever. Because like eventually when it was like, oh, I didn't look the obvious. Okay, so you're infringed. Because like the last step 4 is favoring the side of the patent
Yeah. I don't know. That's a good question. I mean, we had that obvious difference with like.
Yeah, I don't agree with that last step.
Yeah, I'm not sure about the.
It's like.
All right. Exception to the exception to the exception to the rule of infringement. What do you guys think? In the back.
Practically speaking, think that it's good to have a basis to go off of as your legal system, but really we were talking that all this is settled in courts between, arguing on case-by-case examples.
Mm-hmm.
So a lot of it is given to the specifics of a case that you're arguing. And these exceptions really come as a function of time. It's a historical thing, as the issue arises, we need to adjust the law a little bit. But ultimately, it's settled in a case by case basis.
Is it a good thing?
So it's funny because the way we look at the question, it's kind of irrelevant because you need to have a law of some kind, and you need to have some common practice. But practically speaking, it's more on a case by case basis.
Turns out that this isn't actually how Europe, or at least the UK, thinks about this question. And so what we have, and this is going to be my high jump. I swear I didn't actually do high jump in high school. But this will be my high jump. And what we're saying is that the bar was kind of set right here, and you have to get over the bar to show infringement. But it wasn't fair. The bar is too high for some people. And it wasn't fair to make someone leap over this height. And so in some cases, we're going to drop it down a little bit. And this will now be the exception. But it turned out that this was a little too low, and that was a bad thing. So we moved it back up, and we moved it back over here. But that wasn't quite right, because that was still a little bit too high, so that we moved it a little bit right here. We got a little Fibonacci thing going on. So what's another argument? Does this make sense, and would you recommend this? 13.
Yeah.
So the UK court didn't like it because it was a little misleading.
It's not that it's misleading.
So how we discussed is that we think that the British judge said he did not like the system because he found it that the reason we have this convoluted process is because that the source at the top where the claims aren't defined clearly enough so that it's kind of still somewhat open to interpretation. And I believe at least that it would be helpful to not have the system and kind of have folks to work more towards the original prosecution of the patent to define claims more clearly. But that can come in trouble when we're dealing with new technology because we have terms that really doesn't apply to the new invention, but because language change over time. But I think that since patents only has a 20-year period, that language should stay consistent enough within that period to allow for someone to define a new invention in pretty basic and terms that are understanding to the mass majority.
You're talking long enough for me to come up with an example, which is great. So I have a claim, and the claim is for a platform with 3 legs that extend downward from the platform and thereby suspending the platform from the ground. And I go, and you create, so I got this patent. And now you come along, and you make this stool right here. Does this infringe my claim?
I would say no because the differences are not substantial.
Let's talk about literal infringement. Does it literally infringe my claim?
Yes.
I'll write it out. So it's a platform, and it's 3 legs. Extend downward from the platform, thereby creating, or thereby suspending the platform from the ground. Does it literally infringe?
If you flip that stool upside down and put it on the ground, wouldn't it infringe, literally?
Upside down.
Oh, yeah.
Oh, it's going up from the side now. Yeah, okay. Sorry.
No. This is an exact field. Appreciate it. So now you made this. Does this infringe?
I would say yes, but I have kind of a ridiculous. Well, the question seems ridiculous, but I think it's valid. What if your idea sparked this question? So, what if you turned the stool upside down and sold it? Said, "Oh, this is like supposed to be like this." And
It doesn't really matter how it's sold. It's actually the structure. So that structure there. That's why I was kind of forced to change this stool.
But if you turn it upside down, then by definition, the legs.
So that's why this example's a little weak, just because I have ground on there. You actually would never use ground in a claim, because that's a point of reference is typically not used. You typically wouldn't see something like ground in a claim. But I'm trying to get at something that's really simple here so that everyone could understand. Does this infringe? Literally.
No.
I don't think it does. It doesn't extend downward. It extends to the side. It bends downward later on, but when it leaves the platform, it's extending to the side. What are you guys doing in your head? You're getting at the essence of this, or you're trying to do some abstraction of it. But this is all we have, are these words. And when this claim is 100 times more complicated than this, really simple example, we go in there and we're trying to say, all right, well, it kind of does the same thing. Shouldn't it infringe? What are you doing? You're applying this doctrine of equivalence, just like the original judge did in the Graverton case, when he said, like, that's just not fair. He didn't foresee this happening. That's what he meant. He meant, it goes down to the ground. The patent attorney just wrote it poorly. So why penalize the patent holder when this is really what they meant? This is a cheat to get around this claim that extends to the side. And so they thought it was unfair. And because it was unfair, then all of a sudden we have this doctrine of equivalence to say, well, let's try to get at what is the function of this, or how it does this, and the result of this. And all these things are the same. We want this stool to infringe. And if we want this stool to infringe, then we're going to bend the rules of literal infringement. Is this a good idea?
I feel like it takes something that was so objective and clean, something that was written down and is independent of human judgment, and then includes this component of human judgment where someone says, well, I think this is unfair because I kind of know what you meant. And so I feel it makes something clean pretty messy in a way.
Who is a counterpoint to that?
There's a lot that you will have to write down in the claims and dependent claim to cover all sort of changes that would then...
You would just not use the word extend downward.
Well, in that case, but you could also,
It's not the dependent claims, because if the independent claims don't infringe, then the dependent claims aren't going to...
Okay, but just for this one, then the platform, you could, make something that is not quite a platform anymore, and then say, well, this is not a stool, and end up infringing. So,
Is that a good thing or a bad thing for society?
It's a bad thing. That people can go around patents easily by tweaking their own thing.
But what about the things that the inventor didn't think of? Are we going to give them protection on those things too?
Well, I guess that's where the integration comes in, where things are kind of obvious too, but
Obvious doesn't have anything to do with this, yeah.
Equivalence is something obviously in the same spirit as what he had, but it's hard to define what obviousness is.
Counter your point of saying that we want something that's a little bit more defined by saying, well, same way, same function, same result. Is that subjective or objective? I think I heard both answers. And then if we go in and say, well, that's that exception, what's the exception to that? Whether or not you made an amendment to that particular phrase. But clearly, we know whether or not that happened. And then the exception to that is this foreseeable? Maybe that's subjective. Maybe you could go in there and be able to give it to 100 people and they would give the right answer, or the same answer. But even if this was completely objective, what might be the problem with this whole concept?
You keep using the word fair. And you talk about, the patent system wasn't set up to give an inventor an inalienable right to their invention. It was set up to benefit society. And some societies don't even feel that, an invention should remain the property of its inventor. So in this case, I'm looking at this going, does this, meet the initial criteria of why we started the patent system of getting inventions out for the benefit of society? And it sounds like instead it's just kind of, piddling around and benefiting different people, either giving rights to people for a small invention or taking away rights for something that wasn't wide enough. And, just by what's fair, so that changes every few years. As look at the bar you've been setting, it keeps moving around. But
we want to give the inventors the right to their inventions. What is their invention? Is their invention some other version? Their invention? Some thought? Or is it the exact words that they have down there in a claim? Is this the invention? This exact thing right here? We want to give, you're saying that, all right, well, just give the inventors, the rights to their invention. Is this their invention? Because I could tell you from my experience that a lot of my clients don't know how to read claims. And that's what I'm protecting for them. And I ask them to, and they do, and sometimes they're like, yeah, I would change the background section. The background section doesn't even matter. I gave you something and I'm charging you $15,000 for it. This is incredibly important. And you're saying that the only comment you have is on the background section? Did you read the claims? That's the most important part. Yeah, it was really hard. I didn't understand them.
Well, how do you actually capture the essence of an invention? Right now we do it through patents. But if it's some additional ideas, thoughts, questions, perusals this guy had in this entire process, and it sounds like we're trying to not keep it according to what's written down, but what the intent of the man or the person originally was.
Comments on that?
So the case study that we read, the graduate team, so looking at this and the 3D leopard stool, the original definition, that becomes prior art. And so I think the idea that if someone skilled in the art, if they could, knowing that piece, the original stool, would come up with this version, I think that's a legit good test because that's originally how we define whether something's patentable. So it wouldn't really make sense to allow this.
The concepts of the obviousness test, which you're importing now into infringement, that concept actually happens, or is at least attempted quite often. I'm trying to keep a nice clean line between the two so that you guys understand the two different tests here. literal infringement, doctrine of equivalence, how we do infringement and how we do obviousness. And those two things are separate. But I think what you're seeing is a bigger picture, and which is what I wanted you guys to see, is that I've shown this before. And this was obviousness. And what we had before, the bar was too low. And so then I said, all right, well, it's been raised, but we don't really know what it is. When I drew these lines, I drew them fairly solid. Remember when I drew the line for the new obviousness test, I kind of drew this like little squiggly line, as if it really wasn't, it depended on the day. I think that generally, that what we have here generally is an objective test. But we keep on moving it around, and there's exceptions to exceptions to exceptions to the rule. And what I think is a little bit different from obviousness is that it's very challenging to figure out how all of those rules would play out and all those exceptions would play out for the common person when they're looking at a patent and saying, is my company infringing this patent? They could look at those words, they could look at those claims, but they don't really know how this is all going to shake out. And is that a good idea or a bad idea for us as a society? And how do we balance this concept of fairness, because we want the inventor to have rights to their invention, with the rest of society when they're looking at a patent and trying to decide, do I infringe this or not? Well, to decide whether or not I infringe this, I need a $15,000 legal opinion from counsel going into all of the rules and exceptions and exceptions and exceptions, just to get at the simple question, do I infringe? I think that it makes sense to try to balance, but honestly, and my personal opinion on this is that maybe it's the minimalist in me coming out, but the concept of being able to read a claim and knowing whether or not I infringe it, and being able to have my clients be able to do that, and be able to do that without incurring a $15,000 legal opinion, I think makes a heck of a lot more sense. And I think that outweighs any kind of sense of fairness to the inventor. That's just my thought.
Just a side note, but when you talk about fairness and trying to ensure fairness, it seems kind of weird to do that, knowing that all of this is really a function of how much money you have in the end, when you are the infringer or person being infringed upon. So I feel it's really not a question of fairness, right? Because it's not fair that someone who has a lot of money can basically infringe on someone, or effectively not infringe on someone, even though someone with less money would probably end up being called the infringer.
So, true. So we can kind of go back to, and maybe we just use this for one more second of, all right, so the patent holder of this, if this particular company gets away with this, then maybe that's unfair. That this is what they meant. And although these things don't extend initially downward, they do extend eventually downward, and that's what they meant. And so that is unfair. But I also think it's really unfair to the company that's trying to decide whether or not they can make that. And they can't actually figure that out, of whether or not they could enter this market until they actually get this legal opinion to determine whether or not they infringe. And so I agree that this, how do we weigh this sense of fairness and the concept of the money that you have to afford the legal opinions and legal counsel clearly comes into that.
You could counter-argue that the inventor of the three-legs tool also had to pay a lot of money to get his patent. And if his patent doesn't have anything, then the whole thing is meaningless.
And so I actually like the concept of just pushing it back to the lawyer, saying that, you know what, it was unfair that this particular company could have made this, and you know what, the patent attorney screwed up. And the patent attorney should have wrote a better patent application to cover this concept, and go back and sue the patent attorney for malpractice. I actually think that's my favorite answer to this. I take a lot of pride in the quality of my work, and that, I think, would be a mistake. Yeah?
I just had a quick question on something you said. So you said, like, all the exceptions are more objective. But I was a little confused on the Festo exception. That seems like sort of a more subjective.
And whether or not something's foreseeable?
Yeah.
So sometimes technology isn't discovered until later on. And so whether or not that would be foreseeable, I think that that's going to be something that generally could be objective. That this particular concept wasn't, the laser wasn't invented yet. And so, or this particular type of, laser welding wasn't invented yet. And so when we talk about fastening, and then there's a bunch of different types of fasteners, to give laser welding as one of the ways to fasten, that wasn't foreseeable. So I think that there's some, without getting too much into objectivity versus subjectivity, I think it weighs on most of the time the people will come to the same answer. Not the right answer, the same answer. And that's my proxy for whether or not this thing is objective.
That only 25% of patent infringement cases get won. So I was wondering if this is a reflection of the courts favoring the accused, or if it's a reflection of people just suing a lot for patent infringement, or both.
I don't think there's a simple answer to that. I think the answers kind of come into play of this is called the sport of kings. It's incredibly expensive. Maybe it's the patent office's fault for issuing patents that are broader than they should be, and so the patent holder now thinks that they have a right that they don't end up having because in litigation later on that particular patent is invalidated, and so maybe it's the patent office's fault. Maybe it's the patent holder being a little greedy and hoping to extract money out of that particular defendant, and so maybe it's their particular fault. Maybe it's a mindset of society that I should be able to make these copycat goods, and so it's more of the infringer's fault. So I think there's too many, and those are just 3 out of probably 30 different trends that are going on here. So I don't think it's a simple analysis there. I'm assuming at this point that we kind of have somewhat of a handle on infringement. And then I'm going to talk a little bit about, what happens next. There's 2 major types of remedies, and those are an injunction and damages. You could think of this in terms of, I'm going to sue you to stop what you're doing. And that's an injunction. Or I'm going to sue you to make sure that you have to pay me a particular royalty every single time you do this. And that's damages. You can't go back in time and say, I didn't want you to do this for the last 4 years. You can't sue for an injunction on past infringement. You'd sue for damages. Moving forward, you could sue for either one. You could say, all right, I'm going to stop you from doing this, or I'm going to want some damages as you move forward. And this is going to be the rate in which you're going to pay me a royalty. Typically how this works is that you sue for damages of the past, and you sue to stop them from moving forward, an injunction in the future. It's an important concept that tries to level the playing field. And this is just common in a bunch of different areas of the law. And this is the concept of triple or treble damages. And this is a punishment to be able to say, look, you infringed and you were reckless about it, or you willfully infringed, or you did something that effectively exerted your strength or power or size or money or something in the particular field, and we want to punish you for that. And so we would have found a 3% royalty to be reasonable, but the damages now are going to be 9%. And the concept here is to punish that particular defendant, that infringer, so that they don't do this again, so that they're scared from infringing in the future. This particular concept of willful infringement has the consequence of a bunch of different aspects. I know that at Microsoft and a bunch of other very large companies, they don't want any of their employees looking at prior art, ever. They don't want you to look at issued patents. Because if you look at an issued patent, and now you have some notes on it, or it's on your hard drive. And it's later found that that particular company infringed another patent, that particular patent, and you knew about it, and then that could be cause to triple the damages. And so one way around this, and something that you may or may not have heard, was just that don't look at other people's patents. To me, yes. From a startup standpoint, from a Fortune 500 company standpoint, this probably still makes sense. From a startup standpoint, I don't think this makes any sense. And the reason is that whether you're sued for reasonable royalty or 3 times reasonable royalty isn't going to matter. You're not going to survive. And so avoiding the prior art and looking at the prior art so that you could avoid this triple damages, just doesn't make any sense. You're still not going to survive. And so it'd be much better, much more useful to actually know what your competitors are doing so that you could either design around or take some other action. And so I think that this particular advice, which you may have received or may have, someone will tell you, don't look at any patents. I think that's a bad idea. You're going to be caught in willful infringement. Is great advice for large companies, terrible advice for small companies. And this is just yet another example of advice that has the exact opposite type of ramifications, whether it's large or small. This is a new case. It wasn't a new case. This was 5 years ago. But this wasn't in the book. There's a 2-part test that the patent holder must prove to get this treble damages type of award. Clear and convincing evidence that the infringer acted despite an objectively high likelihood that its actions constituted infringement of a valid patent. The state of mind is not relevant to this particular part of the test. And second, that the patentee must prove that the risk was either known or is so obvious that it should have been known to the accused infringer. And this is different than the underwater test that's in the book. A couple different types of lawsuits that a startup might get or might receive. One is that, hey, you have some success and we want a piece of that. And the other is you're in our space, you're starting to eat our lunch, and we don't like it.
Point, is that manifested in, could anyone sue, or does it have to be someone who has a claim or has filed a claim? Could I sue Microsoft for one of their claims?
No, so we don't have any kind of civil right there. You have to be the patent holder. And so if you're the patent holder of a particular patent and Microsoft is infringing that, then sure, you could sue. So, I'm sorry, and then random patent holders, not just random. Yeah, you just can't randomly do this. That's what I mean.
So it's typically for methods that are patented, but so a lot of them are implemented academically everywhere, and nobody cares that there's a patent, and you're still, implementing the method. So I guess because of that, the people who issued those, who owns those patents could sue all students and advisors and everybody who is implementing the method.
Or a system, or a device. Yeah.
Why doesn't that happen ever?
Money in it.
Well, there would be, right? Some, not a ton, but.
For a couple of different reasons. So there's probably not a whole lot. And so that if this is something where, hey, you are now using this particular patented method in your lab, and now the patent holder says, hey, I'm going to sue you and your advisor in Stanford because you're infringing this particular method. The damages there are probably not very large. And they wouldn't justify bringing, a $3 or $5 million lawsuit to get those particular damages. Typically, a company needs to be making on the order of about $100 million to really fully justify a lawsuit. And if you think about it, so you might get 5% of that at a high end in terms of royalty, and that's $5 million, and it cost about $5 million to bring the lawsuit. And so that's typically considered kind of like the lower threshold to patent infringement lawsuits.
How much money the people using your stuff made out of using doing it.
And so if your lab is actually making some kind of revenue on the order of $100 million a year because of that infringement, then you might be, subject to the patent infringement lawsuit. But my guess is that that's not necessarily the case. Yeah.
Does the settlement take into account opportunity costs and attorney's fees? It doesn't.
So most of the time these things are settled. By most, I mean like 85% of the time. And so they're trying to understand that, like, look, the lawyers have the things to, have the most to gain in this particular lawsuit. Let's cut them out of that. And so let's go straight to, look, you're going to spend $5 million, $10 million defending this. What I really want is, $10 million from you, although I'm asking $20 million. And so right there is a settlement opportunity. Not convinced.
I didn't really follow. No. Maybe I wasn't clear with my question. So I'm wondering, so if I say, all right, the damages you caused me are $5 million, but now if I'm going to go after you, I'm going to want more than $5 million because I'm going to have to expend a lot of energy, hire attorneys. So do the courts settle for like $10 million if I win, for example?
Okay, so it was the word settle that kind of threw me off. So settle is typically outside of the courts. And so what you're thinking is more of awarding the actual damages. And so there you might get attorney fees. I don't know how common asking and getting attorney fees are in patent infringement lawsuits. But that would be outside of the damage award. You wouldn't consider that in the actual damage, but you might request that look, we had to defend against this particular lawsuit, and clearly we had some win here. We want the other side to pay for our attorney fees. But that's not part of the damages.
It costs millions to enforce a patent. What's the purpose of getting a patent if your product is potentially only worth less than that?
Great question. That's usually the question that I ask first when people say in cocktail parties, "Oh, I got this great invention. It's a new cap, and I found a new way of doing this." Well, how many of these things are you going to sell? Oh, maybe 100. How much are you going to sell it for? Maybe $1. Probably doesn't make sense. If Walmart's going to pick that up, then maybe it does make sense. So even cheap items, my Starbucks sleeve here, this is probably a pretty cheap item. And this one right here has at least one U.S. patent and a Canadian patent and a European patent and other foreign and domestic patent applications pending. What's the price on this? Probably less than a penny. And so yet this thing could make some sense because it's sold in such high volumes. And so if there's a revenue stream here that's high enough, then it does make sense. But if that revenue stream isn't high enough, then patents don't make any sense at all. And I've turned away a lot of clients on this exact issue. But there's just not enough there to be able to spend $40,000 getting a patent and then to enforce it later on.
In that case, wouldn't the value of that patent be affected by the fact that that one cent device enables you to use the $10 drink?
You can argue that. Sure. So this thing right here isn't really, that invention isn't really a penny, it's $4. That's a great argument. I see law school in your future. That's what you try to do in court, and to try to, when you figure out like what is that that base price that you're trying to use for infringement or damages purposes. And oftentimes you'll see that in claims as well. And so maybe the invention here wasn't that it was a stool, it was a bracket. It was the bracket to attach the leg to the stool. And so this could have just been a bracket for a stool. And then we talk about the bracket. But the bracket was 25 cents. What we really want is a $125 stool. And so we'll often write different claims, different independent claims in the same patent application with damages in mind, especially with something that's very inexpensive. That what we really want is the base price of the stool, and to show the court that this whole stool is made relevant, more marketable, the big markup because of the fact that it has this bracket. And so the damages should be based on $125, not 25 cents. And as you can imagine, as you move that orders of magnitude, that makes a big difference in the damages and the value of that patent.
I don't want to think. So one thing I've heard is toy companies, and IDEO often does this with the toys that they release, is that because those products have such a short life cycle, there's value to them in simply being able to put patent pending on the products, so that another company, it's enough to defer another company from ripping them off. So they'll spend a couple $100 in provisional, then they can put patent pending, but they never actually file the real patent.
Yeah.
Your recommendation for someone who has an invention that might not be worth getting patented? Do you think you should just publicly disclose it?
Yeah, this gets really hard.
And
Is this
someone
something?
picks it up and licenses it?
Yeah, is this something that you try to just get some recognition for? Is this so? What do you do with if the patent doesn't make sense, because there's not enough volume there or the price isn't there? That enforcing it wouldn't make sense. Even getting a patent wouldn't make sense. Then what do you do? And I don't really have a great answer. I mean, maybe there's some open sourcing of that. Maybe there's a publication of that. You're not going to be able to license much there because you don't have a patent. And so if there was something there, I mean, I think a lot of product designers get kind of caught in this. And so, so many items are like right on the cusp. I wrote a patent and it was issued on a buckle about 2 years ago. It was an awesome idea. And that was something where, it's a really quick release and it's easy to snap down. And if that thing were to take off, then sure, I would imagine there's a lot of money in it. There's a lot of messenger bags and backpacks around this room. And I could see that particular buckle on all of them. Or if it doesn't get picked up, then it was a really expensive piece of paper. And so that concept of whether or not this makes sense really comes down to what is that stream that we're protecting and how real is that stream? Yeah.
Damage is only typically 5%, you said, or in that range?
And so it's often, great question. So software might be as high as maybe 20 or 25%, because that's what the margin is, right? So you might think, yep. And so you might think of this in terms of, well, we want that margin. But in a regular good that maybe has only a profit margin of 5, 10, 20%, maybe 25 or even 30, attributing much more than a portion of that, based on this invention seems a little out of balance.
And then in an out-of-court settlement, let's say if the person suing, they were suing a big company, and that product had a big future revenue stream. If they wanted to sort of up the settlement, could they negotiate on an injunction? Like, let's say, well, I could sue you and stop you from making this thing, or you could pay me an enormous amount of money and I'll let you continue to make.
And that is the threat that David can hand over to Goliath, and to be able to say, look, that there is this, we get to stop you. This is a pretty famous Supreme Court case, eBay case, that a patent holder had something that eBay was actually infringing. And that was found. And then the concept of, well, can this particular patent holder shut down eBay because of this? And before the Supreme Court case, typically the answer would be yes, like you have the exclusive right to be able to do this. And then after that particular case, they looked at it in terms of balancing a whole bunch of different factors. And so now you would typically get damages moving forward and not that injunction. And so that the balance of power of what you had and how big that sword was, or how, to be able to stop a huge company from actually doing something like an eBay, like, sorry, we're shut down for the next 2 weeks while we redesign around this patent, that'd be pretty devastating. And that would be out of disproportional to that particular patent holder's rights. And so that was a really important Supreme Court case a little while ago. So I'm going to go back and fix this random people part. But going back and thinking about this, sometimes that random person or random patent holder can be considered a troll. Yahoo sued Facebook right before the IPO. And often in the press or media, they were calling Yahoo a patent troll. It's actually a pretty decently divergent path or expansion of that word. When the word kind of came out, and obviously it's derogatory, but the word was applied to companies that didn't make anything. That they went around and they bought up a bunch of patents, and then they sued people that were making things, and then when they threatened injunctions, or when they couldn't get an injunctions, they still wanted that royalty stream. Most of the patent troll lawsuits get settled out of court, and you bring a lawsuit against maybe a dozen or 100 companies at a time. You kind of pin them against each other in certain ways. I'll give you a license, I'm not going to give them a license, and then you could extract money from them. And that's typically considered what the troll aspect is. The media has kind of expanded this concept of troll to now include anyone who brings a patent infringement lawsuit, which doesn't really make that much sense. If there's two companies and they're competing, and one is infringing the patents of another, and they're both in that space and both making products in that space, I think it doesn't really make sense to actually group that particular type of company in with other companies that don't make anything and go around trying to collect patents and then bring in infringement lawsuits against other companies. It's just my little 2 cents on how do we use the word patent troll.
And the radio was talking about how you have to be able to prove that you can manufacture the product, and you have the capability to do that to get damages. Does that apply?
That's actually, so where did you find that?
So that's under the damages section. It says that to obtain lost profits, the patent owner must prove his manufacturing and marketing capability to exploit the demand.
So that's a slightly different concept of when a patent holder is trying to say these are all the profits that I would have actually gained, but for the fact that this person came in and infringed and kind of stole that market from me. But that's only one way to get damages. And so that lost profits is only one way to calculate damages. There's a whole bunch of other ways to calculate damages. And so that would be a great way to shut patent trolls down. Be able to say, look, you don't get any damages because you weren't actually prepared to make anything, but that's actually not the only way to get damages. Lost profits is just one way. Simply that this is you are benefiting from this particular technology that you are using, and the premium of that benefit that you're selling this at $220, and competitors are selling it without it at $200. And so that premium is $20, and that's the basis of our damages award, which doesn't have anything to do with lost profits. This concept of having a patent holder come in and sue you when you're successful is pretty much inevitable. I just heard a stat the other day that Apple gets sued on a weekly basis for patent infringement from a patent troll. Not from a competitor, from a patent troll on a weekly basis. Largest company in the world, lots of money there, why not? So if you have a patent that looks like it is, then maybe that makes some sense. Does it make sense to bring an infringement lawsuit against a startup? Startups making a few $1,000s. They're just starting off on that particular curve. Yeah.
You can shut them down almost guaranteed with a lawsuit.
Yep. What if they're not? Effectively, should they worry about patent trolls?
They probably have other things to worry about.
I think too many of my clients worry about patent trolls and spend a lot of time thinking about patent trolls because I think that's what the media is telling them, that this is an epidemic and this is really a big deal. If they were to be so lucky to be sued on a weekly basis, that would suggest that they make a couple $1 billion a year. That would be awesome. And they would be able to worry about that and have, maybe that's a worry at that point. But they don't need to be worried about it when they're not making any money.
So are they effectively watching startups? Is that a sort of speculation that they buy patents of companies that can be big in the future and then they wait for that moment?
I think there's too much speculation there. I mean, maybe that makes some sense, but you're effectively giving patent trolls the same type of vision as a venture capitalist, which I'm not trying to make a comment on either one of those parties, but I don't think that's fair. It's not fair to the VC. I think that the patent troll doesn't have that type of time or ability to see that. They're looking towards, and this is what's happening right now, is that typically when startups or other companies go bankrupt, then those particular patents now hit the market. And that particular market, there's a bunch of different players in that market, and some of those players will actively enforce that particular patent against other companies. And so the value of that patent is now the value of extracting damages from other companies. And so the value of that patent might be a lot in someone's hands and very little in other people's hands. And we're going to explore that in a second. These are just some of the numbers that we've talked about kind of all day. A couple $1 million for each side in a patent infringement lawsuit. There's a decent amount of money here for cases that are in the $1 billion range. The most recent one that we heard of course, was Apple v. Samsung. So as a startup, it'd be great to avoid patent infringement. When do we actually do this? You have an idea, and you're trying to figure out whether or not to create a company. Is that when you do it? Right before you raise seed money. Is that when you do it? When you start figuring out what you're going to make, and you have some brainstorming. Is that the right point? When you've decided that this is your design, it's frozen, and you're moving forward. The day before you ship 10,000 units. If you don't actually have a design, it's really difficult to compare it to claims. And so if we don't actually have the design of our stool, then when we compare it to this thing over here, it's really hard. And so when it's too early and it's too conceptual, and when you're trying to read all these claims and it's like, well, do we infringe this? Well, we might. Kind of depends on how we attach the legs. So I guess we'll just put this in the maybe category. And then you look to the next patents, and there are 8 million of them. And you look to the next patent, and you read those claims, and you're like, well, we might do it this way. I don't think we're going to. But George had this other idea the other day that kind of suggests that we might do this. But Susie said that was a bad idea, so probably not going to do that. We'll put this in the probably not category. And you can imagine trying to do this 8 million times, and you're going to have a whole bunch of maybes. And that's not going to actually give you any information that you're going to be able to base a company on. And so you can't really do this too early. And so you're going to get this from an investor if you're a startup company, and you're going to be able to say, they're going to say, all right, well, do you have freedom to operate? Like, well, we don't even know what we're making yet. Well, do you have freedom to operate in this space? Because freedom to operate is one of those things that I'm supposed to check off on my list. And if you either have that or you don't, but I need to know whether or not you have freedom to operate. And so I typically tell my clients, hey, this is seed stage. If it's med device, then it's a slightly different question, but everything else outside med device, I'll loop back to med device in a second. If it's outside med device, I'll say, look, let me talk to them on the phone, and I'll say, look, this is an early stage company. We don't know exactly what we're making yet. And if we find something that's going to be difficult, we have a lot of flexibility right now to design around it. And so if you know of something that we need to be, that is of a particular concern that you have, great, show us. But if you don't have that, then let's assume everything's going to be fine. We have a patent strategy here. There's a patent attorney on board. We know what we're doing, and let's move forward. And that's typically enough, especially in the seed stage. By Series A, we typically know what we're making. And so somewhere between seed and Series A, we'll do a freedom to operate, search and opinion, and to figure out whether or not we're actually infringing something. And if it looks bad, then hopefully we did this early enough so that we don't find out yesterday when we have a meeting with a VC tomorrow. And they ask, well, are you infringing anyone? We're like, yeah, we just found out yesterday. That conversation's not going to go very well. And so you want to do it early enough so that we could actually have an impact or be able to react to that before you have those meetings. But it's got to be late enough so that we actually know what we're doing so that when we're comparing it to claims, we could actually make a comparison. Do we have that or no? Let's make this late enough so that these could go into yes categories or no. Hopefully a lot of no's. There's typically about 3 patents that will keep an entrepreneur up at night. I've done this long enough, and that's a bell curve around 2 or 3. It's rarely ever 0. And so dealing with that patents, we have time, and we have a little bit of money in the bank, and this is great. We could either file a re-examination, or we could convince a VC that this is not a valid patent, or we can now change our design in some way, or we could try to go license. We could do a bunch of different things. We can't do this too early, but we don't want to do it too late. The design's been fixed. We've already ordered all the dies and tools, and we've already spent $3 million, and we've already had them made, and they're coming in tomorrow. That's a little bit late to figure out whether or not you infringe. At that point, I wouldn't even look. This is tricky, because oftentimes then a client will say, well, we need to do this now, and I say, no, let's not do this now. Let's do this a little bit later. But that later happens, and they don't come back, because now they're just sprinting. They have some money, and now they're going off in that direction. And so being able to say, all right, well, at some point in the future, we need to have this conversation, just not now.
What about limited releases like betas and like something like Kickstarter, where you're releasing certain ones, but you haven't ramped up the manufacturing? Can you still be sued at that stage? Or is it considered experimental use?
Kickstarter is a little bit interesting. So is that an offer for sale? You're offering something in exchange for money. It's kind of hard to say that's not an offer for sale. And so if that's an offer, then that's one of the actions that could be an infringement. And so this is kind of a new area of the law of whether or not that's going to be an infringement. I've had clients receive letters based on their Kickstarter programmer. Kickstarter thing. What is that? What is it called? All right, we'll just call it a Kickstarter. This can cost a lot of money, and it doesn't necessarily help the company move forward. Patent application is something that you file, and now you have this as an asset. A letter from counsel saying that you don't infringe, that this particular design doesn't infringe, or product doesn't infringe any patents that they found at that particular time. 6 months go by, that particular letter is now fairly useless, because now you have a whole bunch of patents that have issued since then, and the design may have changed since then. And so that's not actually adding any value to that particular company, but you may be forced to do it. So one of the things that we do is kind of scale the freedom to operate along with the size of the round that our clients are raising. And so maybe this is a $5,000 quick worksheet that you do at seed stage. And maybe it's more like a $10,000 or $15,000 work project later on at Series A or Series B. And when you're raising a ton of money in Series D, then maybe this thing does start to look more like a $30,000 or $45,000 project. But it doesn't need to be that really early on. You don't need that assurance that early. And the thing that we're actually scaling is what companies we're looking at. We don't really care about the fact that there could be a patent troll out there. Keeping in mind that patent trolls aren't going to sue until much later, and patent trolls don't sue to stop you from doing something. They sue you so that they could just kind of bleed a little bit out of you. A competitor, they're taking a swing at your head. But a troll is a little bit different. A troll wants you to actually live on. They want that revenue stream. A competitor wants your head. And so you could take this 8 million patents and shrink it down to probably 80 or maybe 800 and say, all right, this is the focus of our freedom to operate. That's really what your investors are worried about early on. Is there a competitor in the space that's just going to shut us down? That's their biggest concern. They don't care about some bankrupt startup out of Florida. That's not what they care about. They care about, is there a gorilla in this space that has 15 patents in this area that's going to shut us down on day one? Yeah.
Advantageous for the competitor to sue you versus trying to, for example, acquire you?
There's a couple different points. Typically, the point between filing for an IPO and the IPO is a great time to bring a lawsuit. Because at that point, everything's moving forward this way, and they just need to settle. And so that's a terrific time. That particular company is very, very vulnerable. Another way, if you just want to shut them down instead of actually trying to get money from them, might be right when they're about to raise money. Plenty of startups have died in that particular situation. Because at that point, you typically have ran out of money, and so there's actually no way of actually getting up that curve again.
But if you're that much of a threat, why would they just want to buy what you have versus stopping you from producing it?
So they could use this as a threat, or they use this as a stick, and say, look, we're going to bring this lawsuit, and we're going to shut you down, and then you're going to be worthless. And so accept our offer of $3 million to buy your company. It's not to say that those things aren't mutually exclusive. Those things that go hand in hand. Now you see, like, oh, this company is being acquired for an undisclosed amount.
But can't you do that anyway, no matter whether you're infringing on that, since you won't be able to defend yourself?
No. And so, I mean, if you don't have a patent, then you're clearly not going to file that. And if it's close, or if it's not close, then the judge is just going to throw this thing out. And so you don't have to worry about going that far. And if it's not close at all, then all of your investors are going to say this isn't something to worry about. And so, sure, you could bring that lawsuit, but if someone could look at it and say, look, they clearly don't have any claim. Like, the claims here are just complete, they're claiming a desk, and we're building a stool. Like, there's nothing to worry about here.
In many cases, if both are in the same space, there will be a lot of overlap, even if there's no infringement. So they could still have enough patents to be able to threaten a small startup, even if that startup is not infringing, and the startup has nothing to defend itself.
Sure. There's a couple other factors that kind of keep that at bay. If there's a way to defend that particular company, then other companies, private equity firm will kind of step in, or there'll be lawyers that kind of take a contingency fee that might step in. And so there's a couple other things at play there. We've talked about a lot of these options. This will be close to the last question that I asked. If your client receives a cease and desist letter from, which I had a really funny interaction with a client. They called it a cease and desist letter, which I guess is somewhat accurate. Stop what you're doing and die. Letter from a competitor. What are your options? And if this isn't from a competitor, but rather someone, a non-practicing entity, a NPE is otherwise known as a troll, what are your options? There's a couple different here, and it's important to understand the difference between your options in these two cases. We'll talk about that in a few minutes. Turn to your neighbor. All right. So what options do we have here? In the back.
So basically, you can either prove that your product doesn't conflict or doesn't actually infringe on the patent.
Okay.
You can
Non-infringement. Hey, we argue that we don't actually infringe.
Yeah, you can argue that the patent isn't valid either by novelty or obviousness, so you could fight it that way, or you can try and license or come up with a royalty agreement.
So we're going to talk about the first option, which is from a competitor. What's the chances that you're going to actually license that?
Probably not so good.
Okay. Are there any other options there? So we have non-infringement, invalidity. What else do we have?
Or we could redesign our own, or we can form a partnership, or we can sell our company to the competitor.
Sure. So you're going to say, all right, you got us. You win. Anything that you want to throw our direction is great. We'll take 0.
If you're really lucky, you have a patent that they mutually infringe, and you can, work on a mutual licensing agreement.
Okay, let's see what I had. Some of the answers here. So that we don't infringe. That the patent was actually invalid. We could design around it. That helps going forward, but it doesn't help going backwards. And so if you've been infringing for a few years, then you're still going to pay those damages. But you may be able to get around an injunction because you might not infringe anymore because you've designed around it. Similar to hope that you have a patent that your competitor infringes, that's just a hope. You look down at your piece of paper and you look down at your spreadsheet and the answer is no, or the answer is yes. That's not really much that you could do at that point. You can't really scribble it into that spreadsheet. Although you could actually go out and buy a patent that your competitor infringes. This is kind of the hardball play. It's going to, what do you think that patent's going to be worth on the market? What's that?
Varies widely.
Varies widely. How much is it going to be value to you if you're found a lot? And the patent holder probably knows that. That look, you're now trying to buy a patent to save your company. What is $1 less than the amount that's going to bankrupt your company? And that's how much we're going to sell this patent to you for. Hopefully there's a bunch of other patents that are out there, owned by a bunch of different owners. So now that you could say, all right, well, that's great. I appreciate that offer. That's a little steep for us. We're going to go over here and buy this other patent that's actually going to do the same, have the same effect, and it's half the price. And so now we have a couple of different options, and so maybe you're able to kind of work them against each other to be able to get this thing down to a reasonable number. But there's definitely this opportunity for the patent holder of a patent in this last option to be able to say, wow, you really, really need this patent. And guess what? It's on special, 5x sale today. Not regular, but now you get to have this nice increase.
But that particular holder of that patent could have sued the other company as well, right? Because the company obviously is infringing on his patent.
Yeah.
So that holder was just never aware of it. I mean, is that a realistic scenario that there's such a valuable patent out there and nobody has really acted upon it?
The answer to that would be yes. Or maybe that particular company didn't have the ability to sue, or maybe they didn't want to sue. Maybe those particular companies were competitors, and they didn't want to get into a fight themselves. But now you go and take one of their patents and say, this is great, we need this because we're being sued by one of your competitors. Or you guys are partners in this particular thing, but we're just going to go ahead and license some litigation rights off of this, and they go turn around and sue. And those two guys are still shaking hands and going out to the bar and having drinks together, but you're turning around, you grab one of those patents, and now you're suing.
You proactively, buying some of those patents early on so that you have something in case you're sued.
How much are these patents going to cost?
Probably much less when you're not infringing.
Sure, but still, how much are they going to cost? A typical patent on, that's might be covering some interesting technology. It might be $100,000, maybe it's $250, maybe it's $300, maybe it's $50. But whatever that number is, that's a decent amount of money relative to how much money you could do building your own patent portfolio. If you put that $300,000 in the patent portfolio, your own patent portfolio, at the right time, but by the time you do infringe with a decent amount of revenue that you're creating, then maybe you have 6 patents instead of just one that was speculative early on. I'm not saying it's a bad idea, but it's just something that you need to weigh around this. I had a couple clients that had the opportunity to buy patents, and that kind of comes up of all right, well, that's a large amount of money relative to how much we've raised. Does that make sense right now?
Quick question on the pay damages for past infringement. How far back can you sue somebody for past infringement if after they've just redesigned their product? Say 30 years ago they were using your patent for 10 years and they stopped. Can you go back and sue them?
Let's bracket this a little bit more realistically because a patent only lasts for 20 years.
Okay, sorry. 5 years. So 5 years ago they did they're doing one design. Oops, they discovered your patent. They changed the design. You find out, after they've changed the design, they were using your design for that was 5 years, and now you want to sue them. How long do you have to sue them?
So there's not a great answer to that, but there's this concept called laches, and that's effectively a fancy Latin word for you haven't done enough to kind of keep your rights up, and that's typically around the 7-year-ish mark. But you're going to write 7 years down, and it's not really 7. It's anywhere from you reasonably knew this, and it's actually something much shorter, or you didn't know this at all, and it's actually something much longer. And so it's the court's going to decide that.
So reasonable upkeep would include maintaining current knowledge of the area that you're inventing.
Yes and no. So there is no affirmative duty there, but there's more of a you should have known, or you ignored this, or you let this thing happen for too long. I'm going to jump really quickly to the other half of this. And so patent infringement, if this is a troll, you're not going to be able to buy patents to try to find something that the troll infringes because the troll's not making anything by definition, by my definition of it. And so you're not going to be able to countersue a troll. But you might be able to get a license. And that's something that you don't typically have when it's a competitor. That's my last slide of the day.
For more, please visit us at stanford.edu.